Yeah, welcome back to class. Now we are starting from objection and appeal process. What are the objection and appeal procedures we have in our task administrative system? Okay. Yep. Before the taxpayer could object, it therefore means that the taxpayer has disagreed or the taxpayer disagrees with an assessment. Okay. So and for an objection to be relevant, okay, so it must have been given a notice. Okay, so you must have given your objection or notice of objection in writing to the board within the time limit stated in the notice of assessment, which is usually 30 days, okay, from the date of service of the assessment on the taxpayer. Okay, so the notice of objection should state precisely the grounds of objection. In fact, let me state it categorically that we have three conditions. Okay, conditions for an objection to be relevant. So remember, we just discussed the types of assessments we have. We have, apart from the self-assessment, that taxpayers assess themselves based on what they feel it is appropriate to pay as tax. We have additional assessment, government assessment, turnover basis, or deemed assessment approach. So now all of these, apart from the self-assessment, could make the taxpayer object to the assessment. Such just like when the taxpayer submit the assessment, the taxpayer will have to review whether it is they are satisfied or it is appropriate. Okay, so when the taxpayer raise an additional assessment or raise an assessment, the taxpayer has the right under the tax law to object to whatever assessment they have raised, if in the opinion of the taxpayer it is unjustifiable. Okay, so and for this appeal, for this objection to be relevant, it must be in writing. It must be in writing. Okay, so the grounds of objection should be clearly stated. The grounds of objection should be clearly stated, and so conditions for an objection to be valid. Okay, so let's use valid instead of relevant. Conditions for an appeal for an objection to be valid. Okay, so one, it must be in writing. The grounds of objection must be stated, and it must be within the time limits stated or specified in the notice of assessment. Okay, so if a valid objection is made and the board will attempt to settle the disagreement with the taxpayer, if an agreement is reached, the assessment will be amended accordingly, and a notice of amended assessment will be served on the taxpayer. But if no agreement is reached, then the board will give a notice of refusal to amend to the taxpayer, and this notice of refusal to amend, which is otherwise known as NORA, notice of refusal to amend. Okay, so otherwise known as NORA. Okay, may probably lead the taxpayer or force the taxpayer to approach the appeal tribunal. Okay, because once the tax authority issued a notice of refusal to amend, or serve a taxpayer a notice of refusal to amend, the taxpayer, if so wishes, can appeal against the assessment within 30 days. Okay, tax appeals. Okay, so the taxpayer, if so wish, may appeal within 30 days from the date of service of that notice. So all appeals shall, in the first instance, be sent to the body of appeal commissioners. Okay, all appeals shall, in the first instance, be sent to the body of appeal commissioners, except where there is no such body established or where it has been specifically provided in the act that such shall be to the state high court. So, however, a late appeal may be accepted upon an application being made to the Tax Appeal Tribunal or the High Court as appropriate if there is a reasonable excuse for the delay. For the delay. Okay, so under Tax Appeal, we have the Tax Appeal Tribunals. We have the Tax Appeal Tribunal. Okay, so in the administration of taxes, one of the functions of the tax administrator is to raise notice of assessment, and I just mentioned that if the taxpayer is not satisfied with this notice of assessment, that is when a taxpayer is aggrieved by an assessment or demand notice upon him by the service, he or the aggrieved taxpayer, okay, we said it starts from objecting to the said assessment. Okay, but upon the receipt of notice of refusal to amend, then the taxpayer may appeal against such decision or assessment or demand notice within the stipulated period of time to the Tax Appeal Tribunal, which is usually within a period of 30 days from date on which a copy of the notice is received. Okay, so these must be accompanied by such fee as may be described or prescribed, provided that the tribunal may entertain an appeal after the expiry of the said period of 30 days if it is satisfied that there was sufficient cause for the delay. So where a notice of appeal is not given by the taxpayer or by the aggrieved person within the period specified as required, the assessment or demand notices shall become final and conclusive. And the service may charge interest and penalties in addition to recovering the outstanding tax liabilities which remain unpaid from any person through proceedings at the tribunal. In essence, where the service is aggrieved by the non-compliance by a person in respect of any provision of the tax laws, it may appeal to the tribunal where the person is resident, giving notice in writing through the secretary to the appropriate zone of the tribunal. Yes, what we are saying here is that it is not the taxpayer that can file an appeal against an assessment alone. Okay, why it is the taxpayer let's put it this way, why the law allows the taxpayers, okay, that is aggrieved of an assessment of a demand notice received from the FRS, okay, so can appeal against this notice or demand notice from the FRS through the Tax Appeal Tribunal. The FRS too can file an appeal against the taxpayer that have not been complying. Okay, so against the taxpayer that has not been complying with the relevant or with the respective provisions of the tax laws. So specifically, section 59 of the Federal Inland Revenue Service Establishment Act provides for the establishment of the tribunal, while the fifth schedule to the Federal Inland Revenue Service Establishment Act makes provision for the jurisdiction. Okay, so authority and procedure of the Tax Appeal Tribunal. So according to this fifth schedule, pursuant to section 59 or subsection 1 of this act, that is the Federal Revenue Service Establishment Act, there shall be established a tax appeal tribunal, hereinafter referred to as the Tribunal. Hereinafter refers to as the Tribunal. Okay, so to exercise the jurisdiction, powers, and authority conferred on it by or under this schedule, it also states that the minister may, by notice in the Federal Gazette, specify the number of zones, matters, and places in relation to which the tribunal may exercise jurisdiction. Are we together? So now I will discuss what the tax appeal is all about. Now let's look at the composition of the tax appeal commissioners. Composition of the tax appeal commissioners. Composition of the tax appeal commissioners. One. A tax appeal tribunal shall consist of 5 members. Tax appeal tribunal shall consist of 5 members, referred to as the tax appeal commissioners. To be appointed. That's appointment. To be appointed by the Minister of Finance. And then also the chairman for each zone. The chairman for each zone shall be a legal practitioner. Who has been qualified to practice. So that's our qualification. So A is on composition, B is for qualification. Okay, so the chairman for each zone shall be a legal practitioner who has been qualified to practice for a period of not less than 15 years with cognate experience in tax legislation, and then tax matters. Okay, so a chairman shall preside at every sitting of the tribunal, and in his absence the members shall appoint one of them to be the chairman. The quorum at any sitting, the quorum at any sitting of the tribunal shall be 3 members. The quorum at any sitting shall be 3 members. A person shall not be appointed, or shall not be qualified for appointment as a tax appeal commissioner unless he is knowledgeable in the field of law, accountancy, economics, taxation in Nigeria, as well as persons that have shown capacity in the management of trade or business, or a retired public servant in tax administration. A tax appeal commissioner shall hold office for a term of 3 years, renewable for another term of 3 years, only and no more from the date on which he assumes his office or until he attains the age of 70 years, whichever is earlier. So as often as may be necessary, tax appeal commissioners shall meet to hear appeals in the jurisdiction or zone assigned to that tribunal. Okay, so where a tax appeal commissioner has direct or indirect financial interest in any appeal pending before the tribunal, or where the taxpayer is or was a client of that tax appeal commissioner in his professional capacity, he shall declare such interest to the other tax appeal commissioners and refrain from sitting at meeting for the hearing of that appeal. Are we together? Okay, so now let's look at the jurisdiction of the tribunal. Jurisdiction. Jurisdiction of the tribunal. So paragraph 11 of the 5th schedule, paragraph 11 of the 5th schedule to the Federal Inland Revenue Service Establishment Act sets out the jurisdiction. Of the Tax Appeal Tribunal, and these are: 1. The power to adjudicate on disputes and controversies arising from the following tax laws: Companies Income Tax Act, CAP, C21, Law of Federation of Nigeria 2004. We have the Personal Income Tax Act, CAP, P8, Law of Federation of Nigeria 2004, and then 2011, and we have the Petroleum Profit Tax Act, CAP, P13, Law of Federation of Nigeria 2007. We have the Capital Gains Tax. Act, CAP, C1, Law of Federation of Nigeria 2004, and any other law and any other law contained in or specified in the 4th schedule to this act, or other laws made or to be made from time to time by the National Assembly. So the execution of this of its jurisdiction, however, that is the tax tribunal, must apply such provisions of the tax laws referred to in paragraph 11 sub paragraph 1 as may be applicable in the determination or resolution of any dispute or controversy before it. So confirming the jurisdictional power of the tribunal regarding the administration of the Personal Income Tax Act, section 60 of the Personal Income Tax Act as amended by section 14 of the Personal Income Tax Act, okay, number 20 of 2011, provides that the Tax Appeal Tribunal established pursuant to section 59 of the Federal Inland Revenue Service Establishment Act 2007 shall have the power to entertain all cases arising from the operation of this act. So hence, a taxable person being aggrieved by an assessment to income tax made upon him, having failed to agree with the relevant tax authority in manner provided in subsection 3 of section 58 of the Personal Income Tax Act, may appeal against the assessment on giving notice as provided within 30 days after the date of service of the refusal of the relevant tax authority to amend the assessment as desired. So nevertheless, where in the course of its adjudication the tribunal discovers evidence of possible criminality, the tribunal shall be obliged to pass such information to the appropriate criminal prosecuting authorities, such as the Office of the Attorney General of the Federation, or of any state of the Federation, or any other relevant law enforcement agency, such as EFCC. Are we together? So now let's look at the powers of the tribunal. Powers of the tribunal. Powers of the tribunal. Okay, so the tribunal, for the purpose of discharging its functions as noted under the 5th schedule to the Federal Inland Revenue Service Establishment Act, has the power to summon, okay, and enforce, has the power to summon and enforce the attendance, has the power to summon and enforce the attendance of any person, the power to summon and enforce the attendance of any person, and examine him on oath to require the discovery and then production of documents. 3. Receive evidence of affidavits. 4. Call for examination of witnesses or documents. 5. Review its decision. 6. Dismiss an application for default. Or deciding matters ex parte, set aside any order or dismissal of any application for default or any order passed by its experts, and then do anything which, in the opinion of the tribunal, is incidental or auxiliary to its functions under the 5th schedule to the Federal Inland Revenue Service Establishment Act. Procedure before the Tax Appeal Tribunal. What are the procedures? Okay, procedures before the Tax Appeal Tribunal. Okay, so there are rules and procedures guiding the tribunal in the discharge of its duty. So paragraph 15 of the 5th schedule to the Federal Inland Revenue Service Establishment Act, okay, lays down the fact that as often as may be necessary, the tax commissioners shall meet to hear appeals in the jurisdiction or zone assigned to that tribunal. So where a tax appeal commissioner has a direct or indirect financial interest in any appeal pending before the tribunal, or where the taxpayer is or was the client of that tax appeal commissioner in his professional capacity, the commissioner must declare such interest to the other tax appeal commissioners and refrain from sitting in any meeting for the hearing of that appeal. So prior to the sitting on tax matter, the secretary to the tribunal must give 7 clear days notice to the service and to the appellants of the date and place fixed for the hearing of each appeal, except in respect of any adjourned hearing for which the tax appeal commissioners have fixed the date at their previous hearing. So all notices, documents other than decisions of the tribunal may be signified under the hand of the secretary, while all appeals before the tax appeal commissioners must be heard in public. The onus of proving that the assessment complaint of its excessive shall be on the appellant, okay, that is the taxpayer. So according to section 15, according to paragraph 15 subparagraph 7, the hearing of any appeal if the representative of the service proves to the satisfaction of the tribunal, proves to the satisfaction of the tribunal hearing the appeal in the first instance that the appellant has, for the year of assessment concerned, failed to prepare and deliver to the service returns required to be furnished under the relevant provisions of the tax laws mentioned in paragraph 11, and the appeal is frivolous or vexatious, or is an abuse of the appeal process, or it is expedient to require the appellant to pay an amount as security for prosecuting the appeal, the tribunal may adjourn the hearing of the appeal to any subsequent day and order the appellant to deposit with the service before the day of the adjourned hearing an amount on account of the tax charged by the assessment under appeal equal to the tax charged upon the appellant for the preceding year of assessment, or 1/2 of the tax charged by the assessment under appeal, whichever is lesser, plus a sum equal to 10% of the said amount or the said deposit. And if the appellant fails to comply with the order, the assessment against which he has appealed shall be confirmed, and the appellant shall have no further right of appeal with respect to that assessment. Okay, so after giving the parties an opportunity of being heard, the tribunal may confirm, reduce, increase, or increase the or annul, or annul the assessment, or make any such order as it deems fit. However, every decision of the tribunal must be recorded in writing by the chairman and subject to the provisions of paragraph 16 of the 5th schedule, of the 5th schedule to the Federal Inland Revenue Service. A certified copy of such decision shall be supplied to the appellant or service or the service by the secretary upon a request made within 30 days of such decision, according to the Act, where upon the hearing of an appeal no accounts, books, or records relating to profit were produced or on behalf of the appellant. Such accounts, books, or records were so produced but rejected by the tribunal on the ground that it had been shown to its satisfaction that they were incomplete or unsatisfactory. The appellant or his representative at the hearing of the appeal has neglected or refused to comply with a notice delivered or sent to him by the secretary to the tribunal without showing any reasonable cause, or the appellant or any person employed, whether confidentially or otherwise, by the appellant or his agents other than his legal practitioner or accountant acting for him in connection with his liability to tax, has refused to answer any question put to him by the tribunal without showing any reasonable cause, the chairman of the tribunal shall record particulars of the same in his written decision. Are we together? So then we have appeals to the High Court. We have appeals to the High Court. Appeals to the High Court. Okay. So where any of the parties before the tribunal is dissatisfied with the decision of the tribunal, such party may appeal to the High Court, and in line with the paragraph 17 of the 5th schedule. In line with paragraph 17 of the 5th schedule of the FIRSEA. Okay, so appeals lie from the Tax Appeal Tribunal to the Federal High Court and subsequently to the Court of Appeal and then Supreme Court. Okay, so the paragraph states, any person dissatisfied with the decision of the tribunal constituted under this schedule may appeal against any such decision on the point of law to the Federal High Court upon giving notice in written to the secretary to the tribunal within 30 days after the date on which such decision was given. The notice of appeal 5.1 to subparagraph 1 of this paragraph shall set out all the grounds of law on which the appellant's case is based. If the service is dissatisfied with the decision of the tribunal, it may appeal against such decision to the Federal High Court on points of law by giving notice in writing as specified in subsection 1 of this section to the secretary within 30 days after the date on which such decision was given, just like the taxpayer. So upon receipt of a notice of appeal under subparagraph 1 and 2 of this paragraph, the secretary to the tribunal shall cause the notice to be given to the chief registrar of the Federal High Court along with all the exhibits tendered at the hearing before the tribunal. Then the chief judge of the Federal High Court may make rules providing for the procedure in respect of appeals made under this Act, and until such rules are made, the Federal High Court rules relating to hearing of appeals shall apply to the hearing of an appeal under this Act. So as noted or as stated earlier, the role of the court on appeal is limited to a question of law. So a court has no jurisdiction on a question of fact, and then the court cannot reverse an earlier decision simply because the appellate judge would have reached a different conclusion. So further appeal against the decision of the Federal High Court at the instance of either party shall lie to the Court of Appeal and subsequently to the Supreme to the Supreme Court. Are we together? So thank you for being in class. Let's go on break, and when we come back we shall conclude the other parts of this same topic. Thank you.